Okay, this case begins the section of the hostile takeover and defending control part of Chapter 14, assessing the target's response. It's a Supreme Court of Delaware case, and we confront an issue of first impression in Delaware, the validity of a corporation's self-tender for its own shares, which excludes from participation a stockholder making a hostile tender offer for the company's. This is a 1984 case. Justice Moore gives the decision. Part 1, on April 8th, 1985, Mesa, the owner of approximately 13% of Unocal stock, commenced a two-tier front-loaded cash offer for 64 million shares, or approximately 37% of Unocal's outstanding stock at the price of $54 per share. The back end was designed to eliminate the remaining publicly held share by exchange of securities purportedly worth $54 per share. However, pursuant to an order entered by the United States District Court for the Central District of California on April 26, 1985, Mesa issued a supplemental proxy statement to Unocal stockholders disclosing that the securities offered in the second step merger would be highly subordinated and that Unocal's capitalization would differ significantly from its present structure. Unocal has rather aptly termed such securities as junk bonds. Unocal's board consists of 8 independent outside directors and 6 insiders. It met on April 13, 1985 to consider the Mesa tender offer. 13 directors were present, and the meeting had lasted 9.5 hours. The directors were given no agenda or written materials prior to the session. However, detailed presentations were made by legal counsel regarding the board's obligations under both Delaware corporate law and federal securities laws. The board then received a presentation from Peter Sachs on behalf of Goldman Sachs Co., Goldman Sachs, and Dillon Reed Co., Dillon Reed, discussing the basis for their opinions. That the Mesa proposal was wholly inadequate. Mr. Sachs opined the minimum cash value could be expected from a sale or orderly liquidation for 100% of Unocal stock was in excess of $60 per share. In making his presentation, Mr. Sachs showed slides outlining the valuation techniques used by the financial advisors and others depicting recent business combinations in the oil and gas industry. The Court of Chancery found that the Sachs presentation was designed to apprise the directors of the scope of the analyses performed rather than the facts and numbers used in reaching the conclusion that Mesa tender offer price was inadequate. Mr. Sachs also presented various defensive strategies available for the board if it concluded that Mesa's two-step tender offer was inadequate and should be opposed. One of the devices outlined was a self-tender by Unocal. For its own stock with a reasonable price range of $60 to $75 per share. The cost of such a proposal would cost the company to incur $6.1 to $6.5 billion in additional debt, and the presentation was made informing the board of Unocal's ability to handle it. Oh, God. The directors were told that the primary effect of this obligation would be to reduce exploratory drilling, but that the company would nonetheless remain a viable entity. Okay. The 8 outside directors, comprising a clear majority of 13 members present, then met separately with Unocal's financial advisors and attorneys. Thereafter, they unanimously agreed to advise the board that it should reject Mesa's tender offer as inadequate and that Unocal should pursue a self-tender to provide the stockholders with a fairly priced alternative for the Mesa proposal. The board then reconvened and unanimously adopted a resolution rejecting the grossly inadequate Mesa tender offer. Despite the 9.5 hour length of the meeting, no formal decision was made on the proposed defensive self-tender. Interesting. On April 15th, the board met again with 4 of the directors present by telephone and 1 member still absent. This session lasted 2 hours. Unical's Vice President of Finance and its Assistant General Counsel made a detailed presentation of the proposed terms of the exchange offer. A price range between $70 and $80 per share was considered, and ultimately the directors agreed upon $72. The board was also advised about the debt securities that would be issued, and the necessity of placing restrictive covenants upon certain corporate activities until the obligations were paid. The board's decisions were made in reliance on the advice of advisement directors. Wow. Including the terms and conditions upon which the securities were to be issued. Based upon this advice and the board's own deliberations, the directors unanimously approved the exchange offer. The resolution provided that if Mesa acquired 64 million shares of Unocal stock through its own tender, the Mesa purchase condition, Unocal would buy the remaining 49% outstanding for an exchange of debt securities having an aggregate par value of $72 per share. The board resolution also stated that the offer would be subject to other conditions that had been described to the board at the meeting or which were deemed necessary by Unical's officers, including the exclusion of Mesa from the proposal, the Mesa exclusion. Any such conditions were required to be in accordance with the purport and intent of the offer. Unical's exchange offer was commenced on April 17th, and Mesa promptly challenged it by filing the suit in the Court of Chancery on April 22nd. The Unocal board met again and was advised by Goldman Sachs and Dillon Read to waive the Mesa purchase condition as to 50 million shares. This recommendation was in response to a perceived concern that of the shareholders that if shares were tendered to Unocal, no shares would be purchased by either offerer. The directors were also advised that they should tender their own Unocal stock into the exchange offer as a mark of their confidence in it. Another focus of the board was that Mesa exclusion. Legal counsel advised that under Delaware law, Mesa could only be excluded for what the directors reasonably believed was believed to be a valid corporate purpose. The directors' discussion centered on the objective of adequately compensating shareholders at the back end of Mesa's proposal, which the latter would finance with junk bonds. To include Mesa would defeat that goal. Under the proration aspect of the exchange offer, 49% every Mesa share accepted by Unocal would displace one held by another shareholder. Further, if Mesa were permitted to tender to Unocal, the latter would in effect be financing Mesa's own inadequate proposal. On April 24th, 1985, Unocal issued a supplement to the exchange offer describing the partial waiver of the Mesa purchase condition. On May 1, 1985, another supplement, Unocal extended the withdrawal, proration, and expiration dates of its exchange offer to May 17th of 1985. Meanwhile, on April 22nd of 1985, Mesa amended its complaint in this action to challenge the Mesa exclusion. The Vice Chancellor granted Mesa a preliminary injunction, reasoning that the selective exchange offer that included Mesa was permitted. On May 13, 1985, the Court of Chancery certified this interlocutory appeal, and we accepted it on an expedited basis. The issues we address involve these fundamental questions. Did the Unocal board have the power and duty to oppose a takeover threat it reasonably perceived to be harmful to the corporate enterprise? And if so, is its action here entitled to the protection of the business judgment rule? Mesa contends that the discriminatory exchange offer violates the fiduciary duties Unocal owes it. Mesa argues that because of the Mesa exclusion, the business judgment rule is inapplicable because the directors, by tendering their own shares, will derive a financial benefit that is not available to all Unocal stockholders. Thus, it is Mesa's ultimate contention that Unocal cannot establish that the exchange offer is fair to all shareholders and argues that the Court of Chancery was correct in concluding that Unocal was unable to meet this burden. Unocal answers that it does not owe a duty of fairness to Mesa. Given the facts here, specifically, Unocal contends that its board of directors reasonably and in good faith concluded that Mesa's $54 two-tier tender offer was coercive and inadequate, and that Mesa sought selective treatment for itself. Furthermore, Unocal argues that the board's approval of the exchange offer was made in good faith and on an informed basis in the exercise of due care. Under these circumstances, Unocal contends that its directors properly employed this device to protect the company and stockholders from Mesa's harmful tactics. So, where do I see it? I saw fiduciary duty being talked about in this second paragraph. Duty of fairness. So this is the answer to the contention. But where does it say fiduciary duty again? And the court was finding the burden on Unocal. We begin with the basic issue of the power of a board of directors of a Delaware corporation to adopt a defensive measure of this type. Absent such authority, all other questions are moot. Neither issues of fairness nor business judgment are pertinent without the basic underpinning of a board's legal power to act. The board has a large reservoir so all that ness about the business judgment rule and the burden to prove this that duty is really moot until we get to whether or not this is legal activity. The board has a large reservoir of authority upon which to draw its duties and responsibilities received from the inherent powers conferred by Delaware, Title 8 of Delaware Code, Section 141, respecting management of a corporation's business and affairs. Additionally, the powers here being exercised derived from that Section 160 of that title, Part A, conferring broad authority upon the corporation to deal in its own stock. From this, it is now well established that the acquisition of its shares, a Delaware corporation may deal selectively with stockholders, provided the directors have not acted out of sole and primary purpose to entrench themselves in office. So that's the established, by case law decisions, and the rule. So finally, the board's power to act derives from its fundamental duty and obligation to protect the corporate enterprise, which includes stockholders from harm reasonably perceived, irrespective of its source. I've got a couple citations for that quote. Thus, we are satisfied that in a broad context of corporate governance, including issues of fundamental corporate change, a board of directors is not a passive instrumentality. I'm going to keep reading that quote. Even in the traditional areas of fundamental corporate change, example, charter amendments, mergers, sale of assets, and dissolution, director action is a prerequisite to the ultimate disposition of such matters. Period. Move on. Given the foregoing principles, we turn to the standards by which director action is to be measured. So this is literally the answer, is that the corporate directors may engage in self-tender. And I'll just start over here where it says deal selectively with its stockholders, provided the directors have not acted out of sole or primary purpose to entrench themselves in office. So I think that's kind of the next question. Now that we've passed this foregoing principles, returning to the standards for which the director action is to be measured. We held that in this case, Pogostin versus Rice, that the business judgment rule, including the standards by which the director conduct is judged, is applicable in the context of a takeover. When a board addresses a pending takeover bid, it has an obligation to determine whether the offer is in the best interest of the corporation and shareholders. In that respect, a board's duty is no different from any other responsibility it shoulders, and its decision should be no less entitled to the respect or otherwise accorded in the realm of business judgment. From Johnson and Trueblood, there are, however, certain caveats to proper exercise of its function because of the omnipresent specter that a board may be acting primarily in its own interests rather than those of the corporation stockholders. There is an enhanced duty which calls for a judicial examination at the threshold before the protections of the business judgment rule may be conferred. The court has long, so we have to be worried about self-interest, right? And there's a judicial examination, I don't know, for self-interest before confirming business judgment rule applicability. So the court long recognized that we must bear in mind the inherent danger in the purchase of shares with corporate funds to remove a threat of corporate policy when a threat of control is involved. The directors are of necessity confronted with a conflict of interest, and an objective decision is difficult. From Bennett versus Prop 1962. In the face of this inherent conflict, directors must show that they had reasonable grounds for believing that a danger to corporate policy and effectiveness existed because of another person's stock ownership. Sheff versus Maths. However, they satisfy that burden by showing good faith and reasonable investigation. Furthermore, such proof materially enhanced as here by the approval of a board comprised of a majority of outside independent directors who have acted in accordance with the foregoing standards. So outside independent director majority. So we've got a couple, material facts relevant to this inquiry. If the board's exercise of corporate power to forestall a takeover bid, our analysis begins with the basic principle that corporate directors have a fiduciary duty to act in the best interests of the corporation stockholders. As we have noted, their duty of care extends to protecting the corporation and its owners from perceived harm, whether a threat originates from third parties or other shareholders. But such powers are not absolute. A corporation does not have unbridled discretion to defeat any perceived threat by the draconian means available. The restriction placed upon a selective stock repurchase is that the directors may not have acted solely or primarily out of desire to perpetuate themselves in office. And of course, to this is added the further caveat that equitable action may be taken under the guise of law. Chanel versus Chris-Craft. That first quote was from Sheff versus Math. The standard of proof established in Sheff versus Matthews is designed to ensure that a defensive measure to thwart or impede a takeover is indeed motivated by good faith concern for the welfare of the corporation and its stockholders. Okay, so these are your kind of standards of proof from case law, which in all circumstances must be free of fraud and other misconduct. However, this does not end the inquiry. I want to say that's part So it's part I to say that the business judgment rule applies. But then like I sub A is that there is inquiry into applicability based on this inherent conflict, and then part like A1 IA1 is the standard of proof, and so now there's probably another standard of proof. So a further aspect is the element of balance. If defensive measure is to come within the ambit of business judgment rule, it must be reasonable in relation to the threat posed. Okay. So this is, A2. Standard proof number 2. This is number 1. This entails an analysis by the directors of the nature of the takeover bid and its effect on the corporate enterprise. Examples of such concerns may include inadequacy of the price offered, nature and timing of the offer, questions of illegality and impact on constituencies other than shareholders. So those are your factors. I'm going to number them: inadequacy of the price offered, 2, nature and timing of the offer, 3, questions of legality, and 4, the impact on constituencies other than shareholders, like the creditors, customers, employees. I'll just say A, B, and C under 4, and perhaps even the community, D. Generally, the risk of non-consummation and the quality of the securities being offered, that's probably 5. Actually, it's probably 5 and 6. In the exchange. See Lipton versus Brownstein, takeover responsibilities and directors' responsibilities update. Secondary source. While not a controlling factor, it also seems to us that the board may reasonably consider the basic stockholder interest at stake, including those in short-term speculators whose actions may have fueled the coercive aspect of the offer at the expense of the long-term investor. Here, the threat posed was viewed by the Unocal board as a grossly inadequate 2-tier coercive, so that was their threat, 2-tier coercive tender with the threat of greenmail? I don't know what that is. Specifically, the Unocal directors had concluded that the value of Unocal was substantially above the $54 per share offered in cash at the front end. Furthermore, they determined that the subordinated securities to be exchanged in Mesa's announced squeeze out of the remaining shareholders in the back end merger were junk bonds. Is this just more about the threat? I think we're still proceeding with the threat discussion. It is now well recognized that such offers are a classic coercive measure designed to stampede shareholders into tendering at the first tier, even if the price is inadequate, out of fear of what they will receive at the back end of the transaction. Wholly beyond the coercive aspect of the inadequate 2-tier tender offer, the threat was posed by a corporate raider with a national reputation as a greenmailer. Okay. So that's just coercive. Bottom line, coercive. In adopting a selective exchange offer, the board stated that its objective was either to defeat the inadequate Mesa offer or, should the offer still succeed, provide 49% of the stockholders who would have otherwise been forced to accept junk bonds with $72 worth of senior debt. We find that both purposes are valid. However, such efforts would have been thwarted by Mesa's participation in the exchange offer. First, if Mesa could tender its shares, Unocal would effectively be subsidizing the former's continuing effort to buy Unocal stock at $54 per share. Second, Mesa could not, by definition, fit within a class of shareholders being protected from its own coercive and inadequate tender offer. Thus, we are satisfied that the selective exchange offer is reasonably related to the threats posed. It is consistent with the principle that the minority stockholder shall receive the substantial equivalent in value of what he had before. From Sterling versus Mayflower, see also Rosenblatt versus Getty. This concept of fairness, while stated in the merger context, is also relevant to tender offer law. The board's decision to offer what it determined to be the fair value of the corporation to the 49% of its shareholders who would otherwise be forced to accept highly subordinated junk bonds is reasonable and consistent with the director's duty to ensure that the minority stockholders receive equal value for their shares. I agree. Who's even fighting this? Mesa contends that it is unlawful, and the trial court agreed for a corporation to discriminate in the fashion against one shareholder. It argues correctly that no case has ever sanctioned a device that precludes a raider from sharing in a benefit to all other stockholders. However, we have noted earlier the principle of selective stock repurchases by a Delaware corporation is neither unknown nor unauthorized. So, like, the illegality argument, I'm not even sure, like, what is the basis? Has no basis? No basis? The only difference is that heretofore the approved transaction was a payment of green mail to a raider or dissident posing a threat to the corporate enterprise. All other stockholders were denied such favored treatment, and given Mesa's past history of green mail, it claims here are rather ironic. However, our corporate law is not static. It must grow and develop in response to, indeed, in anticipation of evolving concepts and needs. Merely because the general corporation law is silent as to a specific matter does not mean that it is prohibited. You've got Providence and Worcester versus Baker, 1977. In the days when Chef, Bennett, and Martin were decided, the tender offer, while not an unknown device, was virtually unused, and little was known of such methods as two-tier front-end loaded offers with their coercive effects. Then the favored attack of a raider was stock acquisition, followed by a proxy contest. Various defensive tactics which provided no benefit whatever to the raider evolved. Thus, the use of corporate funds by management to counter a proxy battle was approved. Yeah, there's going to be more about this in the next two really long cases at least. So remember, we're in 1985 here. So thus, the use of corporate funds by management to counter a proxy battle was approved. And we're going back here from Hall versus Transluck. So this is some historical case law, I believe. From 1934, Hibbert versus Hollywood Park. From 1983, litigation supported by corporate funds aimed at the raider has long been a popular device. More recently, as the sophistication of both raiders and targets has developed, a host of other defensive measures to counter such mounting threats has evolved and received judicial sanction. These include, so these would be bad, defensive, so illegal defensive measures. On the other side of what's acceptable include defensive charter amendments and other devices bearing some rather exotic app names. And you've got Crown Jewel, White Knight, Pac-Man, and Golden Parachute, which I kind of thought White Knight was okay. I don't know what half the others mean, but each has highly selective features, the object of which is to deter or defeat a raider. Thus, while the exchange offer is a form of selective treatment, given the nature of the threat posed here, the response is neither unlawful nor unreasonable. So that's the holding on, part 1, inquiry A, standard of proof number 2. That's how I've got that. If the board of directors is disinterested, has acted in good faith and with due care, its decision in the absence of an abuse of discretion will be upheld as a proper exercise of business judgment. To this, Mesa responds that the board is not disinterested because the directors are receiving a benefit from the tender of their own shares, which, because of Mesa's exclusion, does not devolve upon all stockholders equally. However, Mesa concedes that if the exclusion is valid, then the directors and all other stockholders share the same benefit. The answer, of course, is that the exclusion is valid and the director's participation in the exchange offer does not rise to the level of disqualifying interest. Nor does this become a disinterested an interested director transaction merely because certain board members are large stockholders. As this court has previously noted, the fact alone does not create a disqualifying personal pecuniary interest to defeat the operation of the business judgment rule from Chef versus Matthews. Mesa also argues that the exclusion permits the directors to abdicate the fiduciary duties they owe it. However, that is not so. The board continues to owe Mesa the duties of due care and loyalty, but in the face of the destructive threat Mesa's tender offer was perceived to pose, the board had a supervening duty to protect the corporate enterprise, which includes the other shareholders, from threatened harm. Mesa contends that the basis of this action is punitive and solely in response to the exercise of its rights of corporate democracy. Nothing precludes Mesa as a stockholder from acting in its own self-interest. However, Mesa, while pursuing its own interests, has acted in a manner which the board, consisting of a majority of independent directors, has reasonably determined to be contrary to the best interests of Unocal and its other shareholders. In this situation, there is no support in Delaware law for the proposition that when responding to a perceived harm, a corporation must guarantee a benefit to a stockholder who is deliberately provoking the danger being addressed. There is no obligation. I like that way of putting it. So that's why they're excluded. Life isn't fair. Thank you, Delaware. There is no obligation for self-sacrifice by a corporation and its shareholders in the face of such challenge. Here, the Court of Chancery specifically found that the director's decision to oppose the Mesa tender offer was made in a good faith belief that the Mesa tender offer is inadequate, given our standard of review. In conclusion, there was directorial power to oppose the Mesa tender offer and to undertake a selective stock exchange made in good faith and upon a reasonable investigation pursuant to a clear duty to protect the corporate enterprise. Further, the selective stock repurchase plan chosen by Unocal is reasonable in relation to the threat that the board rationally and reasonably believed was posed by Mesa's inadequate and coercive two-tier tender offer. Under those circumstances, the board's action is entitled to be measured by the standards of the business judgment rule. Thus, unless it is shown by a preponderance of the evidence that the director's decision was primarily based on perpetuating themselves in office or in some other breach of fiduciary duty, so the business judgment rule applies unless preponderance of evidence showing of all those really bad things. Fiduciary duties such as fraud, overreaching, lack of good faith, or being uninformed, the court will not substitute judgment for the board. With the Court of Chancery's findings, the exchange offer was based on the board's good faith belief that Mesa's offer was inadequate, that the board's action was informed and taken with due care, that Mesa's prior activities justify a reasonable inference that its principal objective was greenmail, and implicitly that the substance of the offer itself was reasonable and fair to the corporation and stockholders. If Mesa were included, we cannot say that the Unocal directors have acted in such a manner as to have passed an unintelligent and unadvised judgment. A decision of the Court of Chancery is therefore reversed and the preliminary injunction is vacated. And there's a note, but it's about a different case. So I'm just going to end this recording and begin. Wait a minute. There's a note on Unocal, though. It's rather short. The specific outcome in Unocal allowing the exclusionary discriminatory tender offer has been superseded by the all shareholders rule to the Williams Act. So this is no longer good law, but it's the beginning of what's going to be a long line of cases, which outs the Delaware law under the supremacy clause of the Constitution. However, the basic standard of the review of defensive tactics adopted in Unocal decision has survived with some glosses as the central rule governing takeovers under Delaware law. Unocal's heightened scrutiny has a reasonable following outside of Delaware. So the logic is still used, but the rules superseded the rule that we enunciated in that last case. So they give you a bunch of cases where they have like a really heightened scrutiny, or at least they're giving a lot of deference to the board. And I'm not reading each of those cases. Well, actually, I will. only by name. You've got International Insurance Co. versus Johns, 89, 11th Circuit. Henry Bear Stearns litigation, 2008, New York. Crandon Capital Partners versus Shelk, Oregon, 2008. Some jurisdictions reject the heightened scrutiny called for by Unocal in the test. The decision under the standard business judgment rule, Schenker versus Laureate Education Co. in Maryland, 2009. This appears to be the approach recommended by the American Law Institute and places the burden of proof on the person challenging the defensive maneuver and states that the board must take account of all factors relevant to the best interests of the corporation and its shareholders. And they give the citation for ALI's Principles of Corporate Governance, Analysis and Recommendations, Section 6.02A-C, 1994.